This is Adam, and he suffers from gout. Try Urol. It helps to prevent crystallization of uric acid crystals in gout therapy. Urol, effective urinary alkalinizer for gout.
Good evening, I'm Camelia and this is KiniNews. Anwar has stressed that the federal court's decision to annul 16 provisions in the Kelantan Syariah Criminal Code today has nothing to do with the government. He also pointed out that the application by the two women was filed during Perikatan Nasional's administration. The government has nothing to do with the federal court's decision to annul 16 provisions in the Kelantan Syariah Criminal Code today. This is according to Prime Minister Anwar Ibrahim. According to Bernama, Anwar said the decision was made by the apex court by the power vested in them under the federal constitution. He added that the decision also has nothing to do with Sharia court or the powers of the state. The federal court, in an 8-1 majority decision today, ruled that 16 provisions in the Kelantan Syariah Criminal Code Enactment 2019 as null and void. The landmark decision was delivered by Chief Justice Tengku Muhammad, who led a panel of 9 judges. The court allowed an application by Nik Elin Zurina Nik Abdul Rashid and her daughter, Tengku Yasmin Natasha Abdul Rahman, to challenge the constitutionality and legality of 18 provisions in the Kelantan Syariah Criminal Code Bracket 1, Enactment 2019. Elaborating, Anwar said the opposition played on religious sentiments in a bid to portray his government as opposing Islam, even though the application by the two women was filed during Perikatan Nasional's administration. He said it is a law of the state of Kelantan. The ones challenging are Kelantanese, and they challenged it in the federal court, not the federal cabinet. Anwar added that the PN government did not protest before when the legal challenge was presented, even though it all happened during their administration in 2020 and 2021. He said now they are protesting and turning it into a political issue. Earlier today, the court had allowed the application by a Kelantan family to nullify the validity of 16 of the state's Sharia criminal provisions. The family had challenged the constitutionality of 18 of the provisions.
A Kelantan family has succeeded in their federal court bid to nullify the validity of the state's 16 Sharia criminal provisions. A 9-person bench chaired by Chief Justice Tengku Muhammad in an 8-1 split majority decision allowed lawyer Nik Elin Zurina Nik Abdul Rashid and her daughter Tengku Yasmin Natasha Tengku Abdul Rahman's petition. The two women were challenging the constitutionality of 18 provisions in Kelantan's Syariah Criminal Code Bracket 1 Enactment 2019. They filed the petition to the federal court under Article 4 Bracket 4 of the Federal Constitution and named the Kelantan government as the sole respondent. The two had claimed that the Kelantan State Assembly does not have the authority to legislate on the 18 offences because there is a federal law that covers such offences. However, the apex court only allowed 16 out of the 18 to be invalidated. In the ruling today, Tengku Maimun said that Kelantan's legislator exceeded its state-making power contained in the State List, Bracket List 2 of the 9th Schedule of the Federal Constitution. She reminded that what the family was challenging was not the position of Islam and the Sharia judicial system in Malaysia, but rather the constitutional validity of the specific 18 provisions of the state, which the petitioners contended breached the limit of state-making power. Chief Judge of Sabah and Sarawak Abdul Rahman Sibli was the sole dissenting ruling. He ruled, among others, that the family has no legal standing to challenge the validity of the Kelantan Syariah criminal provisions.
Still on the topic, the Religious Affairs Minister has called on all parties to remain calm, saying that the decision made by the federal court today did not affect the position of the Sharia court.
Minister in the Prime Minister's Department in charge of Religious Affairs, Muhammad Naim Mokhtar, said all stakeholders and parties involved with the Sharia court will be promptly convened to discuss and assess the next steps for its empowerment. This came following an 8-1 majority decision by the federal court today, which ruled 16 provisions in the Kelantan Syariah Criminal Code Enactment 2019 as null and void. Naim gave the assurance that if there was a need for amendment or reform of the law related to the Sharia court, it would be done immediately. He called on all parties to remain calm and avoid provocation, and said that the decision made by the federal court today did not affect the position of the Sharia court. He said the position of the Sharia court remained intact as guaranteed in the Constitution. In a statement, Naim said as an immediate action, he had instructed the Islamic Development Department together with the Sharia Judiciary Department to get a written judgment on the case. He said after studying the grounds of the judgment, plans will be made to ensure that the agenda of improving and empowering the Sharia court will continue to be carried out. Naim said he will also request an audience with the Yang di-Pertuan Agong Sultan Ibrahim Sultan Iskandar, Deputy Yang di-Pertuan Agong Sultan Nazrin Shah, Selangor ruler Sultan Sharafuddin Idris Shah as chairperson of the National Council for Islamic Religious Affairs, and the Malay rulers to present the court decision.
Meanwhile, in a press conference after the decision, the Kelantan government said they will immediately seek an audience with the Kelantan Sultan to inform His Highness about the verdict.
The Kelantan government will be seeking an audience with Sultan Muhammad V concerning the apex court striking down 16 state Sharia criminal provisions. Deputy Menteri Besar Fazli Hassan told reporters this at the Palace of Justice following the federal court allowing the constitutional challenge by a Kelantan family. He said they were disappointed with the ruling and would immediately seek an audience with the Kelantan Sultan to inform His Highness about the verdict. Fazli explained that the state has also formed a committee to study the apex court ruling, and they are seeking to obtain the federal court's written grounds of judgment to study it. He said it does not just concern the Kelantan government, but it concerns all other states. Fazli said he understood that Prime Minister Anwar Ibrahim and Minister in the Prime Minister's Department for Religious Affairs, Muhammad Naim Mokhtar, are also looking into the matter. He also urged Anwar to gather lawmakers together to amend the federal constitution to resolve the matter.
In other news, two of Mahathir's sons said that compiling 43 years' worth of information is an impossible task and have asked for patience and understanding. Mokhzani and Mirzan were responding to MACC Chief Commissioner Azam Baki regarding their declaration of assets.
Former Prime Minister Dr Mahathir Mohamad's sons, Mokhzani and Mirzan, have responded to MACC Chief Commissioner Azam Baki's statement that they have yet to submit their declaration of assets. In a statement yesterday evening, the brothers said collating 43 years' worth of information is an impossible task and asked for patience and understanding. They said the MACC had given them 30 days to comply with the request and pointed out that they had requested a list of assets going back to 1981, the year their father became Prime Minister. Mokhzani and Mirzan added that they are in the midst of compiling available information and engaging with relevant parties to assist and advise them on the process. The brothers said to avoid any misrepresentation or prejudgment, it would be appropriate for all parties to apply restraint when commenting on this case. They said this is especially when they have not been informed of the specifics of the investigation other than it pertains to their father. On Tuesday, Azam had warned the brothers that they could face legal action if they failed to declare their assets. He said notices under Section 36 of the MACC Act were sent to them, but no response has been received. Azam also indicated that the brothers could request more time once the notice period expires in the middle of this month. MACC called up Mirzan and Mokhzani for questioning last month, although the exact nature of their investigation is unclear.
Moving on to Daim, his lawyer has hit out at Azam Baki's remarks that Daim might have more undeclared assets. He said Azam's remark is unwarranted and smacks of sub judice.
Former Finance Minister Daim Zainuddin's lawyer said MACC Chief Commissioner Azam Baki's statement that Daim may have more undeclared assets is unwarranted and smacks of sub judice. According to Rajesh Nagarajan, Azam's statement was also highly prejudicial to Daim's constitutional right to a fair trial, as the latter's court case is still ongoing. He said this is the latest of a continuing series of statements or comments from Azam and the MACC on Daim's alleged holdings, despite the court charges already pending. He added that apart from direct statements, there are also endless leaks through so-called sources. He told Malaysia Kini that the statements have consistently implied or expressly stated that Daim is guilty in clear disregard of the presumption of innocence, which is the cornerstone of the criminal justice system. He was referring to a Malaysia Kini report yesterday that MACC might summon Daim for questioning again as the agency intensifies its probe into the former finance minister. Azam had said that this was after investigations revealed that Daim might have more undeclared assets. Elaborating, Rajesh said Azam's statement seemed to suggest that Daim is guilty of an offence that is related to the charge of failure to disclose alleged assets. He said the Sessions Court judge also presiding over Daim's case had also advised all parties to the case not to make any statements that would affect the ongoing court proceedings. And it is clear that Azam's comments, which was published widely, is in serious disregard of the judge's advice. With this, he urged Azam and the MACC to respect the justice system and the legal process.
And that is all from me today. For more stories, you can go to KiniTv.com. You can also follow us on Instagram, Twitter, YouTube, and Facebook for the latest news updates. If you'd like to support independent media, do consider subscribing to MalaysiaKini.com. I'm Camelia. Thanks for watching.